Thank you very much for joining us today for this Brodies Academy seminar on the recent rise and return of turnover rent leases post-COVID-19. For those of you who don't know me, my name is Naomi Duffy-Welsh and I am a solicitor in the Brodies Real Estate team, presenting insight today from a tenant perspective.
And I am Matthew Bruce, and I'm also a solicitor in the Brodies Real Estate team. And this morning I'll be looking at the seminar from a landlord perspective.
So if we move on to the next slide, today we will be talking you through some style turnover clauses with the aim of showing you the additional points that come up in between us as solicitors receiving a set of heads of terms and the end product of a turnover lease being put in place. And in the process of doing so, we will cover the different types of turnover rent available, turnover inclusions and exclusions, including dealing with the hot topic of click and collect. We'll look at keep open and authorised closures, how the turnover mechanism will function, penalty charges, alienation, disputes, and confidentiality. And both Matthew and I will be keeping an eye on the Q&A function throughout. So do feel free to raise any questions that you have, and we will try to answer these at the end of each section, as well as having time for questions at the end. So I'll hand over to Matthew now to kick things off.
Thanks, Naomi. I thought it would be helpful at the start of the session if we just had a quick market update on where things stand at the moment and the future really for turnover rents that we see. As you see from this slide here, there are some recent headlines, or turnover rents have been making the headlines recently. Now, I do think that the picture is a bit more rosy than what that is. The headlines there would perhaps indicate, but I don't think it's any secret to say that retail in particular is struggling at the moment, particularly in the wake of COVID-19, but that has been compounded by the recent decline of the high street and with people visiting shops, physical stores, much less often. As you'll see, the headline there from the Scotsman suggesting that 1 in 7 shops in Scotland is lying empty, and we think perhaps that a move to turnover rents is perhaps a way to keep things moving and a positive solution for both landlords and tenants in order to keep the lights on in premises. And also, as I say, the picture is a bit more rosy because what we are seeing at the moment just now is a lot of interaction between landlord clients and tenants to deal with the effects that COVID is having. For example, I'm sure you'll see this as well, we're getting lots of instructions at the moment where landlords are granting rent-free periods, where they're granting rent deferrals, allowing tenants the opportunity to catch up when shops are able to fully reopen, and rent abatements as well. That dialogue between clients, between tenants and landlords is really healthy, and that is something that we see that needs to kind of be there quite to the front with turnover arrangements being put in place. Now, from a landlord's point of view, when we're looking at turnover agreements, what we want to consider is whether there's any base rent that's payable by the tenant to the landlord. Now, generally the landlord will want there to be a base rent there to ensure that there is some guaranteed income coming in, but the form of that can change, it can vary, it can be simply, we've seen instructions where it's simply to cover the service charge or it's to be on top of the service charge. The other question that's at the front of the landlord's mind as well is what actually counts as turnover, and we'll come on to discuss that in more detail in the seminar, but essentially the landlord is looking for as much as possible to be included as turnover. And then the landlord also want to think about provisions to make sure that shops are kept open and trading, and a landlord will also want typically any agreement to be personal to that one tenant and not wider. As I say, it is something that we're seeing more regularly, and I note that particularly hospitality and retail in London are moving towards landlords there are granting turnover agreements and moving towards that model. And we've also seen other big landlords such as Hammerson and Legal in General now moving towards a standard turnover template for new leases. So I think that that is something that's likely to continue. That trend's likely to continue. What I would also like to touch on, and another consideration which the landlord has to think about, and it's perhaps one for you on this call to think about as well, and maybe we can get some comments on that at the end, but it's just how a turnover lease is valued as part of the landlord's portfolio, and how that can affect valuations going forward. So it would be interesting to hear some comments on that as well. And I'll just pass back to Naomi for some insight from the tenant side.
Thank you. So a lot of you will have seen reported in the press that New Look entered into a CVA on the 15th of September this year and secured landlord approval to vary over 400 of their leases to include turnover provisions. So this mass switch to turnover rent was an unprecedented move, but you can see there in the slide that All Saints have since followed suit. And just last week, Clark's launched a CVA, which will result in most of its 320 UK stores moving to turnover rents if approved, although this is still to go to vote. And it is likely that other retailers entering into a CVA will look to this as a possible solution as well. So this move has meant that we are seeing a huge increase of instructions for lease variations or arrears, where with a move to turnover rent, where there may be an upcoming break option in the lease that isn't being exercised, but perhaps the parties are looking to vary the lease to include turnover rent provisions instead, or where the landlord and tenant agree the move to a turnover rent lease in light of a proposed CVA, as mentioned. The significance of this is that before COVID and the New Look CVA, a turnover rent lease would typically be set at a base rate, say around 80% of the open market value, with the turnover rent as a top-up. But now this is changing, particularly with the lease re-gears, where the rents are being based entirely on the tenant's turnover alone. So this means that the way landlords and tenants seek to define gross turnover is increasingly important for calculating the overall rent due. And only a few years ago, we would have tenant clients who would push back on turnover leases on the basis of it being an administrative burden. And now tenants are actively moving towards turnover rent leases and as a means of optimising their position. So it's interesting to see the switch in attitude there as well. I'll now hand back over to Matthew, who's going to talk us through the next slide.
Thanks, Naomi. So this slide here is the set of heads of terms which we sent round in the worksheet prior to the seminar this morning. So what we wanted to do was work from this set of heads of terms as a sort of basic start to take us through the seminar. So we're looking there at what's been agreed between the parties, and we'll come throughout the seminar to have a look at how that translates into the agreement, and we'll flag it at places where perhaps we might need more information. Solicitors typically need more information in order to get the turnover agreement in place. So as I say, we'll work through that as we go, and at the end we'll formulate a set of heads of terms, just discussing or incorporating what we've discussed throughout the session, and we'll circulate that round at the end of the session. So if we move to the next slide here, as thought at the very start, I thought it would be best if we had a quick discussion about what type of turnover rent provisions there are within a lease, and we've sort of touched on them briefly in the introduction there. Now, fortunately, the names just do exactly as they say. So the first one, there's the turnover only rent. As I say, that's very straightforward and is essentially the only rent that's payable to the tenant, to the landlord, sorry, is generated through the turnover that comes into the store. And now, if we're looking at this from a landlord point of view as well, we'd want to make sure that there's some provision in there for the landlord to be paid if the store's not generating any turnover. And we'll come on later on to have a look at some styles or a style clause for that. And also the other important point to remember with a turnover only provision is that there needs to be some element of rent payable by a tenant to a landlord in order to ensure that a valid lease has been constituted. How that's generally dealt with is that the rent will be set out at a nominal figure, and then the turnover provisions will either be contained in the lease or in a separate turnover agreement, which is personal to the tenant and which sets out there how turnover is calculated. Now, the second is the base rent plus the turnover top up, and there's various ways that this can be set out. As I mentioned previously, the base rate of the rent is generally a fixed sum, and it's a point for discussion between the parties what this will be. Generally, it's accepted that it would be 80% of the market value of the lease. Now, the reason for that is that it shows that the parties are seen to be kind of sharing the pain, as it were, of having a value below the market value, but then they get to share. If the tenant has a really good year, the landlord gets to share in that as well. And if the tenant doesn't have such a good year, then the top up obviously won't be as much. So the landlord has to accept that as well. Now, there's various ways that the turnover provisions can kick in. We can have, and we'll come on to look at a style clause in a minute, but we can have simply a turnover as a set percentage when a certain billing threshold is met. We can also see more sort of sophisticated agreements where the increase, or where the turnover increases when various billing milestones are met. So what I mean by that is it's perhaps 10% at sales above 50,000, and then 5% above 200,000, and so on and so on. It just depends what suits that store and what's been agreed between the parties. And the final point I've put on that bullet point there is just about the review of any base rent in a turnover agreement or a turnover lease. It's very important for the landlord to ensure that base rent is increasing and it's reviewed. But looking at that from a tenant perspective as well, you want to make sure that when you're negotiating heads of terms, that there's some discussion about what value the rent will be at. Because remember, as I said, it's generally accepted that it would be 80%. So you don't want it to be initially 80%, and then at rent review, we go straight back up to market value, because then the landlord would be winning really twice there. So that's something else to bear in mind as well. If we flip on to the next slide, I just wanted to take you through a very basic example here of how gross turnover and turnover rent interact with each other. So this is a style that we'd see typically in an agreement, and this here is just for a straightforward turnover as a percentage of turnover rent as a percentage of gross turnover. So what we've got here is the definition of gross turnover, and we'll come on to discuss what that means later on in the seminar. But as I said previously, generally the landlord wants as much as possible to be included in that figure. And the reason for that is because the turnover rent is then generated as a percentage, in this example, of the gross turnover. So in this example, it's 10%. So I've just used very straightforward figures to illustrate that. So if the gross turnover is £100,000, then the turnover rent would be generated at £10,000. And then if we flip on to the next slide here, this is slightly more complicated, and this is bringing in the thresholds which I was talking about previously. So again, we've got the definition of gross turnover, and this time the turnover rent doesn't kick in until a turnover threshold is met. So in this example, we've got the turnover rent being 10% of the difference between gross turnover and the turnover threshold. So again, if we use the same figures as before, the gross turnover is £100,000, then the difference between that and the threshold would be 50,000, and your 10% turnover rent is calculated on that figure, and that gives you the rent coming in as £5,000. Now, as I did say, these can be negotiated, and more sophisticated agreements can be reached between the parties where we have different turnover thresholds and different turnover percentages being generated at various levels of sales. So that again is something to think about as well. And then if we go on to the next slide, I mentioned that what a landlord would be looking for in a turnover only lease would be that there would be some provision for default rent to be paid. So if we look at this clause here, that's exactly what that does. That just says that if the premises are not open for trading at any point when they should be, that the gross turnover, because it's not trading, there'll be no gross turnover, so the turnover rent can't be calculated, so the tenant will just pay a figure of, in this example, £50,000 to the landlord. That, of course, is quite a controversial point, simply because if the shop's not open and not trading, then the tenant will not be generating any turnover. So it can be quite controversial from a tenant perspective. But again, that's something that a landlord would want to have in place, and is something to be discussed between the parties as well at that stage. And I will pass back to Naomi now.
Thank you. So moving on now to gross turnover, inclusions and exclusions. Having a clear list is important for preparing the turnover certificate, which certifies the total amount of gross turnover for a turnover period, and which the landlord uses to calculate the actual turnover rent due and any penalties. So when we consider these, we need to consider the key question: where is the tenant's income coming from? And this can be one of the most contentious points between landlords and tenants when putting a turnover lease in place. So if the client has any strong preferences on them either way, including these in the heads of terms can be helpful to streamline the process, although I do appreciate this depends on the discussions had. So in part 2 of the worksheet, we've asked you to consider which items you would look to include as income when acting for the landlord. And to explain what some of the items in this table are, you can see we have deposits there. So thinking about renting a pair of bowling shoes, for example, you might deposit a small sum for the shoe hire. We've got vending machine sales, the sale price of gift vouchers. VAT will come into the business on the sale of goods where these items are not VAT exempt. And then we've also got in there items such as rent paid by a subtenant or other occupier of the premise, bad and doubtful debts, and so on. So I'll just give you a moment to have a look over that. The table is, of course, non-exhaustive, and we will come back to these items shortly. But if we now go over to the next slide, Matthew and I have prepared a quick poll for you on which items you would, if acting for a landlord, include in the gross turnover. So if we can have a look at the poll, please. There we are. So this is just to gauge your initial thoughts. and we'll go on to explain what some of the items are in the next slide. So we have item A, which is deposits, item B, which is the sale price of gift vouchers, item C, which is internet orders collected by customers from the premise, and then you can put in all of the above and then none of the above. So we'll let you have a moment to vote there. Matthew, can you see how the voting's getting
I can,
on?
yes, we're getting some results in at the moment.
Great, that's good.
We'll maybe just give it a wee bit longer, but let's hope we get the results of this poll sooner than recent ones have come in.
Yeah, sounds good. Perfect. So we're just really thinking about what's happening with the money here in each of these scenarios as to whether or not that would be included or excluded in the gross turnover. So there we go. So how are we, Matthew? Do we have the results more or less in?
We're still sort of seeing a bit, but I think it's sort of plateaued now, yeah. We do, it's actually quite an even spread across the board here. What we've got for, I would say we've maybe got quite a tenant-friendly audience here. We've got really not more than 50% have gone for either A, B, or C. So the results there are that really that none of them would be included, but we have got a few, we've maybe got a third of the audience who are saying that they would all want them all to be included if you're acting for the landlord. So those people there are the landlord friendly people.
Yes, they would be. Yes, so as you say, Matthew, the landlord would be looking to include as many of those items as possible, and then acting for the tenant, we would be looking to include as few as possible. And if we go on to the next slide now, we can see a few of the positions that might be negotiated depending on the parties and their instructions. And I should flag that as this is my slide, this is a very tenant-friendly position in the table there. So as I mentioned when the poll was up, we need to think about what's happening with each of these items. So if we look at deposits first, if we think about the pair of bowling shoes again, the money comes into the business for the shoe hire up front, but then when the shoes are returned, the deposit's paid back to the customer. So acting for the tenant, we would look to optimize the tenant's position to include deposits at the time of receipt, but then we would deduct them if and when we paid to the customer, as you can see in red in the column to the left there. Again, with gift vouchers, the customer will come in and pay money for the voucher, and that money goes into the till where the money is converted into a credit note for the store. And this credit note may or may not be spent depending on whether the customer then forgets to redeem their vouchers after Christmas, for example. So with gift vouchers, the landlord may look to include these at the time of sale, but the tenant may push for inclusion if redeemed and to the actual redemption value. So the position in the table is what we might aim for when acting for the tenant on that one. Then if you look in the left-hand column for gross turnover exclusions, you can see that the last one there, rent paid by a subtenant or occupiers excluded, which is only taken where the subtenant or other occupiers' gross turnover is to be included and taken into account when calculating the tenant's gross turnover, as Matthew will shortly explain. And if you can see in the bottom left-hand column there, acting for the tenant, we would only look to include the amounts received for delivery, postage or insurance, which exceed the actual cost of those items, so that the running costs of the business aren't taken into account, but any profit on them would be for turnover. So a few of you might have noticed that source C isn't in that table. And if we go on now to the next slide, to look at internet orders collected by customers from the premise, aka click and collect. So this is quite a hot topic at the moment. And the question here is whether the premise are being used as a post box. The landlord will argue that the sale benefits the tenant as a whole, and so if it benefits the business as a whole and it's collected from the premise, it should be included in the gross turnover. And the tenant will argue that the customers have had no interaction with that store for the purchase, and so the items should not be included. And to flag, there is no right or wrong answer on this, and the outcome will depend on the preference of both the parties. But if we are looking for a midpoint, we can perhaps bottom this down to, if the order is satisfied from stock at the premise, as you can see in red there on the slide, it would count in the gross turnover. But if the order was satisfied from stock sent to the premise from another store or from a warehouse, as shown in blue, it would not be included in gross turnover. And the same applies for whether the items are paid for at the premise or whether they're paid for online. And Matthew, I know that you have some points from a landlord perspective on this.
I do, yeah. Just on this point specifically, what a landlord would be, or what landlords now are becoming more sophisticated and looking at other sources of income that might be coming into a premises, not solely from the stock that's sold there. So the example really there that springs to mind is if the units have maybe got Amazon Prime or Amazon lockers there where items can be collected, or if other sort of delivery mechanisms where tenants, where customers are picking up packages from shops that aren't being sold by that shop. So you maybe want to have a think about that as well. And also what comes in here is Deliveroo or Uber Eats or the like, where the tenant, the client, sorry, the ultimate customer, sorry, has not had any interaction with that store at all, not even entered the store. And you know, should that be included as turnover there? Again, that's evolving, and as Naomi says, there's no right or wrong answer to these, but it's really the landlord wants to make sure that as much as can be caught as possible is caught. And I just wanted to flag that final paragraph on the slides here. What this is saying is that, as you touched on in the previous slide, is just that any turnover that comes in from the unit, whether that's the actual tenant that's bringing that in, or it's a licensee or a concessionaire, the landlord wants to ensure that all the turnover generated is included in the calculation for the rent. So the example that springs to mind here, and I'm not sure if Boots operate on turnover leases or not, but if you go into that shop and there's stands, various different stands in there selling different things, makeup and perfumes and things, that all of those sales would be included in the overall sales for the shop. And I think just before we move on to the next question, the next slide, sorry, we've got a question here, maybe best for you, Naomi, just talking about the click and collect. Somebody's mentioned here that what happens in the instance of where there's almost a reverse click and collect. So for example, I think the example here is Zara. They've got shops where you can go in and order on an iPad in the shop, and then but the delivery is just sent to your house. So what do you think would happen in that scenario?
Well, that's a really interesting point, actually. I've not come across that before in a draft. Well, I guess if acting for the tenant, you would want the landlord to have either one or the other. So you'd be looking for either the click and collect to be included in the gross turnover or the reverse click and collect to be included. You wouldn't want to have both, particularly if they are the mirror image mechanism of each other. But that's actually a really interesting point. And I guess it shows how fast the technology is evolving as well, with what retailers are employing in their stores and how this area of law is changing. So that was a good question. Thank you.
Okay, if we move on to the next slide, then I will take us through in this slide the various keep open provisions that you would expect to find in a turnover agreement, as well as you know, when the shop can be closed and what happens where it's closed when it's not supposed to be. You can see from the first bullet point I've put on the slide there is there'll generally be a definition of trading hours within a turnover agreement. In fact, the landlord will want to ensure that that's definitely in there. Now, I suppose in this instance, it depends on how, in each individual scenario, how your transaction is being set up. If it's a lease with turnover provisions, you will obviously have the keep open provisions in the lease, which still apply, and these just sort of supplement it to deal specifically with the turnover being generated. So they're not exclusive, and they sit alongside each other. Now, the landlord, as I say, obviously wants the shop to be open and trading for as much as possible, but they do accept that there are times when the shop does need to be shut. And I've listed some exemptions there, which you might expect to see or might be negotiated between the parties. The first one on that slide there is the requirements of any local or other competent authority. So that's perhaps most relevant at the moment. So what's envisaged there is if the shop has to shut for any reason and it's mandated by either the local authority or the government that it has to do that. The example there that springs to mind is the current COVID lockdown. And there's obviously also the provision in the lease that the tenant has to abide by statute. So the landlord can't expect the tenant to be open. What I've put there is just some wording that really would be quite favourable to the tenant in that instance, because what that's doing there is that's saying that if not opening the store, or if opening the store, sorry, would cause a breach of any law, then it can be closed. But also importantly, what's caught there is any government guidance as well. So that's maybe where the instance where just now the Scottish or the Westminster government are saying that some shops shouldn't open, but it's only guidance, it's not law. The tenant would want that there to protect themselves, to say that they don't need to open the store. The next one on that list there is just where the property is damaged or destroyed, and also taking into account if the premises are in a shopping centre or maybe a retail park. The important thing for a landlord in this instance to think about is just whether how the wider centre is defined, and making sure that any provisions or any damage to one end of the centre which doesn't affect the other end, that's differentiated to make sure that shops where there's no damage can still be opened. And then the next two on this list, Naomi and I were having a chat about this beforehand. These are quite tenant-friendly provisions, and I think Naomi was saying that she struggles to get these in sometimes. But really, the other options are that when the tenant's carrying out any permitted alterations to the premises, or where they're doing an assignation of the let. Now, it's important for that point just to think that doesn't affect the turnover. As I say, landlords generally want turnover agreements to be personal. So just because it's been assigned doesn't mean that the actual provisions would pass on, but it's just if the shop's shut in order to assign the lease, then the tenant won't be in breach of the contract at that point. And then the next two really are just the landlord recognising that the tenant has to operate a business and will need to train staff and do stock taking. So that is obviously permitted. The important thing here, again, is for the landlord is just to make sure that the provisions are limited. So it's not, they can't close for half the week and say they're staff training. So in this example, we've limited it to 2 hours per week, and stock taking would be four days in an account year. And I think that's generally accepted between the parties as being standard. If we move on to the next slide there, this deemed turnover provision, now I'll give you a moment to have a quick read through that clause there. What this is trying to capture is where the shop isn't open but it should have been, and in that instance what your deemed turnover is going to be in order to calculate your turnover rent. Now this is slightly different from the slide we looked at the very beginning, which was what would happen if the shop was closed and there was no turnover, what rent would be payable there. And this, we're looking at how you calculate what the turnover would be if the shop was shut. So you can see in this example that if the shop's not open when it should be, then the deemed turnover will be either, or will be the higher of, sorry, the average daily gross turnover for a turnover period, or the actual turnover achieved during that day. So this is just to protect the landlord, to ensure that if the shop's not open, there is a deemed turnover coming in, and this is how you calculate it. Now, what you need to think about in this instance, what we need to be careful of, is just having how you do the comparison. So here I've got a daily average across the whole year. That could be a month-on-month comparison, or it could be a yearly comparison. What you have to consider, and particularly if you're acting for a tenant here, is what periods are being compared to each other. So you wouldn't want February sales being compared to January, because they're just not going to be the same. So overall, you want to try and achieve a fair comparison which reflects what is going to be achieved by the store at that time. And then if we flip on to the next, and I'll pass back to Naomi for that.
Great, thank you. So now it's time to look at how the turnover rent payment mechanism will function. So turnover rent is commonly paid in 2 ways: either payment on account, which operates a bit like payment of service charge, where payment is made upfront with reconciliation after the actual turnover rent is ascertained, and payment in arrears, after the tenant's turnover certificate has been produced and the turnover rent is calculated at the end of each period. Again, this can be another point of contention between the parties. So if this was agreed early on in the negotiations, we would expect to see it in the heads of terms. If not, we would need to take instructions. It does depend, of course, on what the parties agree. But if the heads of terms do not specify on account payments, the tenant might look to better their position by pushing back against the wording in the first 10 of the drafts. And this is because the tenant hasn't earned their income yet from trading, and it's in their interests to have the rent paid in arrears to reflect the cash flow and the success of trading in each turnover period. I know, Matthew, you have some points on this from the landlord.
Yeah, really, a landlord will typically be coming at this from the opposite end of the spectrum, and they'll be looking for the funds to come in as soon as possible, really just to keep their cash flow going, to ensure that the payments coming in to them as soon as it's, it can.
And so you can see from the slides there that the process is quite similar, with the exception being that turnover on account is the turnover rent's paid up front on the basis of estimated figures. And on account is more likely to apply in cases where the lease is turnover only. So if on account, the tenant will not want the first year's turnover rent to be based on a reasonable estimate of the landlord, which the landlord could pluck out of thin air with no knowledge of the tenant's business, but instead to be a fixed figure which is agreed between the parties in advance and included in the lease. The second year turnover on account figure can be the turnover rent payable under the first year of the lease, or the tenant might want it to be a fixed percentage of this, so it could be 70, 80, 90% of the previous year's turnover rent instead. And if on account payments, there will be reconciliation so that any overpayment will be put forward to the next turnover rent payment under the lease, or paid back to the tenant at the end of the lease, and we'd want interest to apply there on any late payment. And in respect of underpayment, this must be paid by the tenant within a set number of days of the landlord's demand, and again, interest would apply on late payment. So alternatively, payment can be made in arrears, and the tenant can provide a turnover certificate at the end of each turnover period and pay the turnover rent in arrears within a set number of days after that, once it's determined. Payment in arrears is more common where the tenant also pays a base rent, say 80% base rent, and then the turnover period is shorter so that there's more regular cash flow for the landlord. There is a choice in the length and frequency of turnover periods. So the turnover periods can be annual, quarterly, or monthly. But the shorter the period, the greater the administrative burden on the parties in providing the turnover certificates, calculating the turnover rent, and doing audits as well on a more frequent basis. So for administrative ease, the parties may want annual reconciliation at the end of each financial year instead of at the end of each turnover period. And it's also possible to have on-account payments with the turnover period being 1 year and annual reconciliation, but that then the tenant makes monthly payments of the turnover rent based on the estimated figures. Annual reconciliation is important as well for dealing with any spikes in trading in light of the threshold provisions that Matthew was talking about earlier. As if the reconciliation is quarterly, then for 3/4 of the year, the tenant's trading may be below the threshold, but it might spike over Christmas with the peak trading, kicking in the step threshold levels into play. So acting for the tenant, we would look for annual reconciliation of the turnover as a means of dealing with these peak trading times, while payments may be made monthly or quarterly to help the tenant's cash flow. And as a final note, when acting for the tenant, we would want to make sure that the time period for the turnover certificate to be provided and the time period for the tenant to pay the turnover rent once this is ascertained is long enough for the tenant to actually make the payment without the turnover rent being late, as interest will apply on late payment and penalties may be due, as Matthew will shortly go on to. In addition to being provided the turnover certificates, the landlord can do an audit as well of the account records, which again Matthew will touch on. And then when acting for the tenant, we want to make sure that the landlord doesn't offset the administrative burden and the costs of the audit against the tenant via service charge under the lease. So if the lease does contain service charge provisions, we would look to include an express exclusion for the costs of the audit from those provisions as protection. So I'll now hand back over to Matthew, who's going to take us through penalty charges.
Thanks, Naomi. If we flip on to the next slide here. So what this does is this is just the provision in the agreement which kicks in if the tenant hasn't complied with their obligations in order and to produce the turnover certificate. So having gone through agreeing what counts as turnover, and then producing the certificate, we want to make sure that the landlord's protected, to make sure that that certificate is provided to them, and then they can calculate the rent on the back of that. So the first clause that we've got here, and I'll take you through 3 scenarios, but this scenario is if the tenant fails to produce the turnover certificate in the first year. So what this clause says here is that if they don't produce it in the first year, this says first turnover period. As Naomi said, it can be monthly, quarterly, yearly. For ease, I'll just say yearly at the moment. So if they don't produce the turnover certificate at the end of the first period when they should, then the tenant will have to pay a sum equal to £50,000 in this example to the landlord. Now, that £50,000 there, that's the figure that would be open to negotiation between the parties, and that's often, this clause is probably where we need to take most of our instruction from, that figure often hasn't been discussed between the parties, and you want to avoid the scenario, as Naomi said, where the landlord just picks a figure. So what we would be thinking about in this instance is just what is the anticipated turnover going to be in year 1. Again, the landlord would be looking for the tenant to disclose that up front, and then we need to make sure that the tenant is also incentivized by that figure to ensure that they comply with their terms, with their obligations under the lease. So that's the first scenario. If we move on to the next slide, we can look at another scenario. So in this case, we've got the instance where the tenant hasn't produced their first turnover certificate, and then in the next year they don't produce it again. What that clause there says, and I'll give you a moment to have a look at that. Now, that's quite a legalistic clause, but basically what that clause says there is that if they don't do it in the second year and they've not done it in the first year, then they pay the same amount again. But it won't be exactly the same, because if there's been any payments over the period to the landlord, then they'll be offset and taken into account. But again, as I say, that just provides the protection for the landlord to ensure that even where the tenant hasn't produced their turnover certificate, that there is a rent that can be paid. And then finally, if we move on to the next slide, this is the scenario where the tenant has produced their turnover certificate in the first year, but then fails to do so in the next year. Again, I'll give you a little moment to have a look at that clause. Again, it's legalistic, but what this says here is that if they don't produce it in the next year, then the sum that they have to pay to the landlord will be 110% of what they paid in the first year, or what was disclosed on the turnover rent that was paid in the first year off of the back of that first turnover certificate. Again, that figure in red there, 110%, I've just picked that out of the air at the moment, and that is something that again can go back and forth between solicitors. So that is a point to be bearing in mind as well. If that can be agreed up front, then that obviously would make things a bit smoother when we come to do the drafting. But often landlords and tenants haven't even thought about it at that stage, so it's something to bear in mind. And then I think before we move on to the next slide, are there any questions that have come in, Naomi? Or
yes, there's just there's one that's popped up. There's a question. So why does the landlord require a turnover certificate if they have access to the turnover information and then the account records as well?
Mm-hmm. Yeah, that is a really good question. I should have mentioned that actually at the start of this seminar. Sorry, this section. The turnover certificate is provided by the tenant, and it's provided by an accountant. So it's audited and it's certified by the accountant to give it the accurate position of what is what the turnover at that unit is. The other information that the tenant provides to the landlord isn't audited and it isn't certified.
Great. Okay, so moving on to the next slide now, we're just going to take a quick look at alienation. So what is the ability of the tenant to assign or sublet their interest under a turnover lease? So a turnover rent lease may only be agreed between a landlord and a tenant if that specific tenant is trading well or has a prominent brand. If the turnover rent is then assigned to a company which is not trading as well as the tenant, the landlord will be stuck with lower footfall visiting the premise, lower trading figures, and this will lead to an overall lower turnover rent being paid. So the wording on the slide there just reflects the market standard position that the tenant isn't normally permitted to assign or sublet or part with or share possession of the premise while the turnover provisions are in place. And this point is particularly important with lease re-gears, as if the heads of terms say alienation as per the existing lease, and the tenant makes an application to alienate their interest, the landlord will be bound by the terms of the existing lease, which may be consent not to be unreasonably withheld or delayed to an application, and then end up with a lower turnover rent being paid as a consequence. So for tenants, we want to make sure that the turnover agreement would apply to the tenant or a group company, and this just gives them some flexibility with any restructuring that might take place or how they operate the business from that store. And there are different types of turnover agreement as well. So just to flag, you can have a lease with turnover provisions incorporated into it, or you can have a lease variation which will vary the terms of that lease by adding turnover provisions in, or a turnover agreement which will sit alongside the lease as a separate document, and that will be personal to the tenant. So if the tenant then assigns their interest, the turnover agreement falls away and the rent reverts back to a base rent in terms of the lease itself. So just to hand back over to Matthew, who's going to have a look at disputes.
Thanks, Naomi. Yep, we'll just have a quick look at this slide here. This is just what happens if there's any disputes between the landlord and the tenant, and what happens in that event. Obviously, there's quite a lot to have been agreed between them, so there is scope for things to maybe go wrong at some point. The tenant has an obligation under the lease to keep accurate accounts records, and I know you're going to have a quick chat about them in the next slide. But essentially, that's all the information that they have and provide to the landlord in order to calculate the turnover. And the landlord is entitled to inspect these once per turnover period, unless there's an exceptional reason for doing otherwise. And the landlord's also able to audit these records, as you touched on previously. So if in this event, I've put a style here, a clause that a landlord would want to put in, that if the gross turnover is found to have been understated by more than 2%, then the tenant would meet the cost of that audit. Now, any disputes between the parties about gross turnover or turnover rent would be referred to a chartered accountant in order to determine the outcome of that dispute. And I'll pass back to Naomi for the next slide.
So with confidentiality, some key points to consider. So a turnover lease requires the tenant to be honest, transparent and realistic about their own financial performance, and this requires an unusual degree of openness on the part of the tenant. So the information to ascertain the gross turnover is going to be highly sensitive for the tenant's trading position, and we need to strike the right balance between providing the landlord with the information they need to accurately ascertain the level of trading and the turnover for that store, without putting the tenant at risk of their commercially sensitive information being exposed to competitors. So what is the tenant required to provide? So the account records on the slide there usually includes all books and documents or records, including computer tapes, discs and other storage items, cash register receipts and tapes, bank statements. So those items are typically requested, and you can also see there that sometimes the landlord can request a VAT return, but this only really works for smaller independent businesses trading from one premise as opposed to large chain retailers. And just the reason for that is the VAT return contains that information about all of the tenants trading, which is excessive and also not particularly helpful for the landlord determining what applies to one specific premise. Sometimes the turnover agreement can make provision for the landlord connecting their computers up to the tenant's tills as well, as you can see in the second clause there. The tenant will likely object to this on grounds of cybersecurity, but it also goes beyond the market standard position, which is that the tenant provides the turnover information, the turnover certificate, and then the account records for the landlord to audit if the landlord requires to do so. So to go beyond this is slightly excessive, and the tenant will likely try and push back on that basis. And then with reference to the bottom clause there on the slide, the tenant will want to oblige the landlord to keep this information confidential, and so we'd make provision in the lease for the landlord not to disclose this, except where required by law or to their legal advisors, or even to interested parties looking to purchase the property and acquire the landlord's interest. But this disclosure would only be permitted where on a confidential basis, so as an additional protection there for the tenant. And the landlord may also want to keep the existence of the turnover agreement or lease confidential itself, so as not to weaken their position getting a new tenant in after the lease ends. So if that was the case, we would look to see if the usual wording for registration would be removed from the draft, so that the document wouldn't be uploaded and registered in the public register once the lease is finalised. And if we move on to the next slide now. So I do appreciate that the wording on the heads of terms is quite small here, so these will be circulated after the session, but it just gives you an idea of what a set of heads of terms might look like, incorporating some of the points that both Matthew and myself have discussed. So you can see there that there's keep open wording there. We've also got a note of turnover inclusions and exclusions, and some other points as well, inventory and confidentiality. So obviously it does depend on what discussions are had with the client at heads of term stage, but there's just some key points to have in the back of your mind, which might streamline the process for us when drafting.
And I would just, sorry Naomi to jump in there, just I'm conscious of the time. I note that there is a few questions that have come in at the end there, so perhaps when we circulate the heads of terms, what we'll do is we'll put a note of those questions and the answers to them at that stage as well. Yeah,
that sounds good. So if we move on to the next slide now. There we are. So I think, do we have time for one question there? I'll just pick, I saw this one come in after the end of the alienation slide. So there's just a quick question on whether a landlord can allow an assignation if they believe that a new tenant has a higher turnover. And I guess this would depend on what the provisions of the lease said and what were agreed at the initial heads of terms stage. So while this is a good scenario for the landlord, it would depend what was the provisions of the lease were contained in the at the original point of drafting. So if assignation was permitted, then it would be allowed. But if that hadn't been agreed at the early stages, which reflects the market standard position, then the landlord, the current tenant might struggle to assign. And then, do we have time for? We'll circulate the rest of the questions after, as Matthew said. Great, well, thank you very much for joining us today. It's been a pleasure to have you along. We look forward to you joining into the next seminar, which is coming up in a couple of weeks' time. Just to flag to everybody that following the seminar today, a short questionnaire will pop up just to ask for some feedback. So if you have a moment or two and you can complete that and send some feedback in, that would be much appreciated. But thank you very much for everyone attending, and we hope to see you all in the next session. Thank you.